to the post of inspector, Your Worship, according to the revision ROP 2010 rules, the pay of a promotee is fixed as per Rule 13, whereas the pay of a direct recruit in the same post is fixed as per Table 2 of Rule 15. And while implementing the said rules, the pay of a promotee is fixed lower than the pay of a direct recruit in the same post. So now, when the petitioner was promoted to the post of sub-inspector, his pay was fixed as per Table 2, Rule 15, which is the rule for pay fixation of a direct recruit. But subsequently, when he was promoted to the post of inspector, the respondents held that his pay should have been fixed as per Rule 13 of the revision of pay rules 2010. Thereby, his basic pay was reduced by the respondents after more than a decade. And then we had challenged the pay fixation by filing a writ petition. But since we had not challenged the rules, Rule 13, the Honorable High Court had held that the writ petition is not maintainable. We had filed a writ appeal also, but subsequently we had withdrawn the writ appeal. And at page 96, Your Worship, is the Honorable Division Bench order. The operative portion is at page 97. Your Worship, I'll read from the third para. Keeping in view the fact that Rule 13 of the 2010 rules had not been put to challenge by the appellants in WPC 89 of 2023 or in the present appeal, we do not find any infirmity in the prayer made by the appellant's counsel. The writ appeal is accordingly dismissed as withdrawn with liberty as given as prayed for as per law. So, Your Worship, the main grievance of the petitioner, if I may take a lordship to page 37. Annexure 3. Your Worship, this is the last pay certificate of the petitioner when he was holding the post of Sub-Inspector of Police. At paragraph number 3, Your Lordship will see he has been paid up to May 2022 at page 37. Your Lordship will see his basic pay out here is 57,400. This is his last pay in the rank of Sub-Inspector. Now, if I may take your lordships to page 38, this is his first pay certificate after being promoted to the post of inspector. And if your lordship will see, middle of the page, the basic pay has been reduced to 55,200. So while he was holding the post of sub-inspector, his basic pay was 57,400. Subsequently, on his promotion, his pay has been refixed as 55,200 basic pay.
On what basis?
This, Your Worship, is according to the respondents due to the implementation of the ROP 2010, Revision of Pay Rules 2010. According to the pay of promotee has to be fixed according to Rule 13 of the ROP 2010. At page 33, Your Worship, this is the extract of the Revision of Pay Rules 2010. And at page 34, Rule 13 gives us how the pay has to be fixed on promotion on after 1/1/2006. And if I may take your lordship to the next page, the relevant portion at page 35, Rule 15 is for the rule which is concerned with pay fixation for direct recruits. So Rule 15, Table 2 is concerning fixation of pay of direct recruits. Previous page, page 34, Rule 13 is for pay fixation of promotees. So in such a situation, Your Worship, when the pay is fixed for a promotee on or after 1/1/2006, his pay is fixed at a lower pay scale than a direct recruit in the same post. although both are having the same duties, same pay scale. So that is why we have challenged the constitutional validity of Rule 13, saying that due to the implementation of Rule 13, the pay scale of a direct recruit and a promotee, there's a difference in the pay fixation. There's a pay anomaly has arisen because of the implementation of Rule 13 and Rule 15, Table 2.
This is for the rank of sub-inspector.
Yes. In our case, it is in the case of the post of the petitioner was holding the post of sub-inspector.
Now,
He's promoted to inspector.
but the salary is lesser.
Yes. On his promotion to inspector, the respondent said that no, when you were promoted to sub-inspector, your pay was wrongly fixed by adopting Rule 15, Table 2. And his pay was rectified as per Rule 13. And due to that, his basic pay was also reduced.
So this basic pay is for the sub-inspector or for the post of inspector?
Your Worship,
This pay is 35.
page 35, Your Lordship.
Direct recruitment
This
of
is for direct
sub-inspector.
recruits. Direct recruits, yes, sub-inspector. At the bottom of the page, grade pay is 4,400. The pay band is 10,520. The total pay is 40,920. So this is the pay for direct recruits.
Which one? Page 35.
Page 35. But if when the pay is fixed as per Rule 13 for promotees, then the pay becomes lower, although the pay band is the same, Your Lordship.
Okay. So yes, please notice.
Yes, Your Lordship, notice has to be issued to DIG, Your Lordship, since rule is challenged.
Okay. Heard Mr. A. Malhotra, non-counsel for the petitioner. Also heard Miss Marian Chan, learned government advocate. Government advocate?
Yes,
Not
Your
me.
Lordship.
Okay. For respondent number?
1 to 5, Your Lordship.
All the response.
Okay. So appearing on behalf of all the state, on behalf of the state respondent for all the respondent, staff. By filing this writ petition, the petitioner has challenged.
Rule 13.
Hmm?
We have challenged Rule
Okay.
13 of the ROP 2010.
Validity of the Rule 13 of the Mizoram within bracket revision of pay rules, 2010. 2010. Okay. On the ground that it resulted in fixation of promotees, sub-inspector of police appointed honor after 1/1/2006. Lower as compared to the entry pay of a sub-inspector of police directly recruited on or after 1/1/2006. Start. We are also challenging the petitioner also challenged the consequential pay slip dated 19
Yes, Your Worship. At
8
page,
2022.
page 38.
Yes, yes. This is the pay slip of this inspector.
Inspector.
Okay. Nineteen 8/2022. reducing the basic pay of the petitioner from rupees 57,400 per month to rupees 55,200. The petitioner has also challenged the communication letter dated 17/2/2022, 9/3/2022, and the letter dated 13/4/2022. Stop.
Representations were rejected, Your Worship.
Whereby the representation
Were rejected.
filed by the petitioner has been rejected. Representation filed by the petitioner for refixation of the pay has been rejected. Stop. Para. Issue notice. Returnable by 4 weeks. Stop. Since Miss Mariel Chante, Lani Government Advocate, appear and accepted notice on behalf of all the respondents. No formal notice is required to be issued. Stop. Para. Release the matter after 4 weeks.
Your Worship,
Your Lordship, a notice has to be issued to the AG since
AG,
rule is
okay.
challenged.
So a separate,
Yes.
since you are issuing, since you are appearing, separate notice is to be
Yes,
issued.
Your
to-
Lordship.
Okay, since the rule, since the constitutional validity of the rules
Rule 13.
13 has been challenged, let a notice be also issued to the Advocate General. Okay.
Obliged.
For admission, item numbers 2 and 3.
My Lord, in item number 2 and 3, as per this honorable court's order dated 23/1/2026, I have to produce several reports, my Lord. And till date, my Lord, it's not finalized. If I may be granted some more time, my Lord.
So to file compliance affidavit.
Yes, my Lord. My Lord, your Lordship will see at order dated 23/1/2026.
20?
23 January 2026.
Just a minute. Huh? Yes,
At para 4, my Lord.
yes,
Considering all the above, we are of the view that the following needs to be done by the state respondents.
yes.
The state respondent should trace out the remaining land documents of respondent number so and so. 5 sets of photocopies of all the land documents of the parties should be made, out of which 2 sets should be submitted to the court. And my Lord, certain directions have been made. And at 5, the Secretary to the Government of Mizoram, Director, Land Revenue and Settlement Department shall trace out all the connected papers relating to the issuance of the above land passes to the parties herein, to clarify how those land passes came into existence, inasmuch as the Assam rival had been apparently occupying the land for more than 100 years. Para 6 also, my Lord. The Revenue Department shall prepare a list of officers who gave approval for issuance of the land passes to the landholders. The designation and name of the officers should be mentioned in relation to each of the passes issued to the parties. This may clarify whether the land passes have been issued with the approval of the government or whether the same have been done only at the directorate level. The competency of the officer who gave approval for issuance of the land passes will also more or less be determined by this said exercise. So, my Lord, in view of this, my Lord, I have to file a compliance affidavit, but this is taking time because there are many landowners, my Lord. If I may be granted some more time.
So can we grant it? Okay. Miss Linda L. Fambal, Land Erosion Advocate General. Raise for how much time?
My Lord, 4 weeks may be granted.
For the 4 weeks time to file a compliance affidavit. The affidavit in compliance with the order dated 23/1/2026. The prayer so made by the Land Advocates, the Additional Advocate General has not been objected to by the Land Council for the petition. Accordingly, the prayer is allowed. Stop. Mr. A.R. Malhotra, Land Council for the petitioner. In item 2 also, Mr. Malhotra is the petitioner.
Your Worship,
With the
I'm
Land
the
Council for the petitioner.
Your Worship, in I'm not,
Okay, item 3, huh?
since these matters are clubbed together, Your Worship, common order will.
Yes, yes. And who else is present?
My Lord, for respondent number 1 through 6 and 7 in item number 2. In item number 3, I am for respondent number 61 to 63.
Okay.
Your Lordship, I'm appearing in item number 3.
Okay, Miss, that one, huh? Lalan Pui, huh? Land Council,
Respondent number
No.
43 in item
you have got respondent number?
43.
No, the earlier one.
My Lord, in item number 2, I am for respondent number 1 through
1, 2,
6 and 7.
6 and 7.
In item number 2,
And in item number 2?
61 to 63.
1 to 6.
61. Oh, item number 2.
Okay, and Miss,
I'm appearing on behalf of respondent number 43 in item number 3.
okay, respondent 43 in item 3. Okay, and Mr.
F. Lalelian, my lord. I'm appearing for respondent number 49 and 53
Respondent
in item number 3.
Okay, 49 and 53 in item number 3. And Mr.
My lord, in item number 3, I am appearing for respondent number 58 and 59.
And 59. Okay. And Mr.
Lord, in item number 2, I'm for the petitioner.
Okay.
And
petitioner.
in item number 3, for the respondent 6, 10, 12.
His name should come after Mr. Malhotra, huh? Is it for the petitioner.
Yes, my lord.
Okay.
Item number
After
2.
Malhotra. Thereafter, rest. Okay.
Item number 3, I'm for the respondent 6, 10,
And
12,
item number,
14,
item number
17.
6, 10.
Respondent number
Respondent
6,
number 6.
10, 12, 14, 17, 19, 22, 23, 24,
Okay.
26, 27,
Okay.
28.
Present, huh? Okay.
As per the cost.
It's part of the cost list, my lord.
Okay. So when do we fix? After 4 weeks date or just after 4 weeks? Only after 4 weeks. Need to fix a date then. Okay, as requested. Let this matter be listed on. When?
2nd or 2nd September.
2nd September. Okay.
Second September.
Item 4.
My Lord, as per this honorable court's order, we have filed the affidavit, an additional affidavit on 24/7/2026. However, my Lord, there's some new developments. Seems that there's a meeting on 3rd August 2026.
Okay.
So this also will need to be incorporated in the affidavit, if I may be allowed to.
You have already
Fine.
filed otherwise.
Yes, my Lord. I
In
have filed
compliance
it
of the
previously.
order dated, the last order dated 15/7/2027, 26. There was a direction.
Your Worship, as per the affidavit filed on 24th of July, the meeting minutes of the meeting held on 14th of July 2026 have been.
Yes.
filed in the honorable
There
court.
there has been filed.
Now, Your Worship, I believe there was another meeting,
Okay, thereafter.
yes,
After that.
and it was held on 31st,
3rd August.
3rd of,
Third, okay, that is new development.
Yes, my lord.
that,
Okay.
those meeting minutes have to be filed.
Okay. Heard Mr. A.R. Malhotra. Will Gibson? Yes. No. Land Standing Council, Gauhati High Court. Also heard Ms. Linda and Pambul, Land Additional AG for the state of Mizoram. And Mr.
F. Lalalian, my lord, for respondent number 2.
For respondent number 2, okay. Stop. Ms. Linda Pambul, Land Additional AG submits that although they have filed affidavit in compliance of the order dated 15/7/2026. However, there has been some new development, a subsequent new development, and therefore she praised that. Some subsequent new development which need to be brought into record. So, therefore she praised that she may be allowed to bring on record the new development by way of filing additional affidavit. The prayer is allowed. List the matter on
Next,
as
after a week, my lord.
After,
as agreed upon by the parties. List the matter on
it is 15th, 19th.
19th,
19th
19th August.
19 August.
Item 5.
My lords, in this contempt petition, I want to make one submission, my lords, because I think there is a willful disobedience of the court's order by the respondent number 6 in this contempt case, my lords. And if your lordship will come to the order sheet, my lords, if your lordship will come to the order sheet dated 8/4/2026, this is my lord's order, where my lord had highlighted the reasons for this contempt petition, my lords. Well, I'll read from paragraph 1 because it's not a long order, my lord. It says like this: the suo motu contempt proceeding has been registered pursuant to the order dated 27/3/2026, passed in PIL suo motu number 2 of 2024, whereby this court directed the registry of the Gauhati High Court Aizawl bench to register contempt proceedings against the person found to have violated the court's earlier order dated 18/7/2024. The relevant paragraph of the order dated 18/7/2024 is reproduced below. On considering all the above facts, this court directs that no new construction activity shall henceforth be allowed on either side of the Bongkon Durtlang Leighton Road. Further, any construction activity that has started but where the construction activity has not surpassed completed one floor of the said construction of any building, the same shall be stopped immediately. Any construction activity in relation to the petrol pump to be built on the side of the said road should be stopped immediately. Paragraph 3. In compliance of the order dated 18/7/2024, the AMC had issued a prohibitory order dated 19/7/2024 restraining the construction. My lord, I'll not read that order. I'll go to paragraph number 4. Subsequent upon a report submitted by the amicus curiae, Mr. Joseph Rente, indicating continuing violation of the court's order, this court, by order dated 22/10/2025, directed the AMC to verify the allegation and submit the report. In compliance of the said direction, the AMC has reported that 6 persons have violated the existing order of this court dated 18/7/2024 by continuing construction activities in violation thereof. Upon perusal of the material available on record, including the report of AMC Aizawl, this court is prima facie satisfied that a case of civil contempt is made out against the said 6 persons for willful disobedience of the order passed by this court on 18/7/2024 and 22/10/2025. Then, my lord, paragraph number 6 lists out the contemptness, and I'm talking about the contemptor number 6, my lord. This is Lalram Thanga, proprietor of Brookfield Enterprise. Now, my lord, it goes on to say like this: calling upon the alleged contemptors to show cause as to why the proceeding under the Contempt of Courts Act 1971 shall not be initiated and appropriate action be not taken against them for willful disobedience of the order dated 18/7/2024 and 22/10/2025, passed by this court in PIL suo motu number 2 of 2024. In the meantime, the AMC shall ensure that no further construction is carried out in violation of the court's order dated 18/7/2024 and shall file a fresh status report before the next court date of listing. Now, my lord, steps were taken subsequent to this order, my lord. Steps were taken for service upon all the respondents listed out in this order.
Okay, so the respondent number 1.
Now,
probably
respondent
has filed
number 1,
affidavit.
2, 3, 4, and 5 are represented, my lord.
Okay. So
Now,
what
respondent number 6, we have taken steps upon the respondent number 6 also, my lord.
have received.
He has
Yeah.
received and he has submitted a letter, my lords. And I believe that letter is also with in the file itself, because I have also been served a copy as per the last
Letter before?
letter before this honorable court. He has sent a letter to this court, my lord.
Okay, not the affidavit.
Not affidavit, but he has sent a letter. I believe the letter is in this court, my lords. It's in the file. This is a letter dated 13/7/2026, my lords. He has written in his individual capacity and not through an advocate.
Okay.
My lords have got it.
Yes, yes. Still, I have not seen.
My lords, I will quickly read out this letter. It says like this, my lord, paragraph number 1. That I, Sri Lalram Thanga, proprietor, Bhutril Enterprise, son of Lalbiak Thanga Bongkon, West Aizol, am the rightful owner of House Site LSC number 103001/01/2118 of 2009, granted by a competent authority which is located at the roadside of the Bongkon Durtlang Road, downside of the National Highway, and that all land revenue and taxes have been paid up to date. That the area within 50 feet horizontal and 20 feet vertical from the edge of the road on both sides of the Durtlang, Bongkon, Chanmari and Bongkon Durtlang Road are illegally declared as protected area by the Municipal Commissioner AMC on 30/3/2006 due to verbal pressure of the then minister concerned and wrongly prohibited construction of any kind of structures within the said area. Again, the said areas is notified as protected area under provisions of section 12(7) of the Master Plan for Mizoram Vision 2030 in order to protect and conserve natural heritage by the then Secretary UT and PA Department, and the said notification dated 26/2016 was authenticated in the name of Governor Mizoram, concerned Minister of UT and PA Department. It may be noted that neither the AMC nor UT and PA Department has no right to declare any land over which private parties have valid land passes, LSCs, issued by Revenue Department, Mizoram. As such, the order dated 30/6/2016, issued by AMC, and notification dated 26/2016, issued by the then Secretary UD and PA Department, are baseless and cannot be regarded to have valid legality before the eyes of law. Moreover, the allegation of business of duty and PA and Department do not place the subject for their purview. In fact, the action of AMC and UD and PA Department is regarded as misuse of power. That the order of AMC dated 30/3/2016, my lord, I believe this 13/6/2016, my lord, is with respect to the same area, and notification dated 26/2016, as stated above, are in contravention of Article 13 of the Constitution of India, read with Article 31A and 300A, and that Section 12(7) of the Aizol Master Plan for Aizol Vision 2030, prepared by Intact Mizoram Chapter, is neither an act, law, or rules duly made in the Assembly House nor passed by the legislatures and obtained by the consent of the Governor of Mizoram. This clearly revealed abuse of power on the part of UT and PA as well as AMC, and that the Honorable Minister, UT and PA Department, etc. Mizoram, was approached by the landowners' welfare on 4/12/2025 over this illegal order and notification. On that day, the Honorable Minister, UT and PA Department, told us that the department is not willing to obstruct private landowners to construct buildings within their respective land. If any form of construction or structure within this area is proposed, due process of law for acquisition of those private lands will be followed. As such, until and unless land acquisition process is completed, we will not take any action in line of this order and notification to deprive our private land. That this Honorable Court, in its order dated 23/11/2023 in WPC number 110 of 2020, already directed UD and PA Department and Revenue Department to take final decisions within a period of 2 months from the receipt of this order by passing a speaking and well-reasoned order by para 8 of the said order. However, having no interest to acquire the said land, the two departments concerned failed to make final decisions till date. In this connection, the plaintiff, convener Intact Mizoram Chapter, appears to have no knowledge about this issue, but by virtue of his personal position and interest, he might be willing to deprive the property of poorer sections of the people without considering the law as enshrined in the Constitution of India. That a temporary shed constructed by me within my house site LSC 2118/2009 do not encroach upon the public premises. As such, this Honorable Court is highly requested not to issue eviction or demolition order, but to close the whole chapter of the case for the end of justice and fairness of things. Lastly, I would like to bring to the kind notice of this honorable court that the landowner welfare in the recent past approached the AMC authorities with a request to withdraw or cancel the order dated 30/3/2016, which is under active consideration by AMC. Now, my lord, the reason I say this is because it appears to me, my lord, because the issue here is not whether he has a valid LSC or not, because everyone along that road, my lords, have valid LSCs. And that is why constructions have been happening left, right, center, and landslides have been happening. And so the issue in the PIL, in this suo motu PIL, my lords, was with respect to the landslide that has been happening along that road. And because of that, this court had passed a strict order saying that no construction should be done at present. And the case is yet to be disposed of, my lords. And in the meantime, he has submitted this letter. It appears to me, my lord, that of course this is between the court and him, my lords. I will not ask this court to pass any direction as such. But my humble duty before this court as an amicus is, my lord, to bring to your kind notice of his letter. And it is my respectful opinion and submission, my lord, that this action on the part of the respondent number 6 appears to be in complete disregard, my lord, to this honorable court's order.
He probably has also undertaken that until and unless the land acquisition process is completed, we will not take any action in line of this order.
My lord, what he's saying is,
In line of this order and notification to the any private land.
what he's saying is, my lords, that unless land acquisition proceeding is initiated, they are not going to comply with any order issued by the government or even by this court. That's what he's essentially saying, my lords. I'm not sure how we can disregard this kind of letter. Because, my lords, every single individual who wants to construct, my lord, including the government, they have filed an IA and the government has been given a permission to do construction. And then there was one other client also, my lords, of Mr. Malhotra, who had also filed an IA. He has been allowed to do the construction. Now, the correct procedure would be, my lord, to file an IA. But this person, my lord, he has intentionally disregarded the court's order.
It was directed to AMC to ensure that no further construction is carried out.
Correct, my lord.
Who represent AMC?
My lord, because this is a contempt, my lord, the AMC has not been presented today. They are not made parties in this.
They are not a party.
They are parties in the main, my lords, but not in this.
And probably we need to know the correct position of this respondent
Point number 6.
through AMC, actually, in the main.
In the main,
Whether-
the reason, my lords,
Because-
the reason, my lords, this contempt proceeding was initiated was because, my lords, in the main petition, they had filed a report. The AMC had filed a report wherein the AMC had clearly stated that he had violated the court's order and then constructed a shed. It's not a basic shed, my lord. It's a very permanent shed. And it's because of this construction, my lord, this suo motu contempt has been initiated. Now, he has received notice in this suo motu contempt petition, and then he files this letter, my lord. I understand if he was saying we will not construct for now, but the way he has mentioned, my lord, is that he's saying we have no intention of obeying the court's order. I mean, whether the court's order is correct or not is one thing, my lord. But that intention to not obey it unless and until the acquisition process is taken or some steps has been done, my lord, I feel is a little bit on the side of
This is respondent number 6.
deliberate disobedience. Yes, my lord.
But 6 is represented by Jordan Puya Namte.
No, my lord. 6 is unrepresented.
Jordan Namte Land Council submits that he has instruction to appear on behalf of the respondent number 2, 3, 4, 5, and 6.
6.
Yes,
My lord, he's not. No.
he need to file in the form of affidavit.
On the last,
Is he present, Jordan Puya?
my lord, I think in the last court's
Last order 22/7/2026.
7. Because I think in the last court. Okay, I probably have missed. I'm sorry.
Para 3. He represented respondent number 6 as well.
My
Oh,
lord,
no,
if
again,
your
next
lordship will
line,
see,
again, next line, it says that,
insofar as respondent
yes,
number
yes,
6.
next line again says, 6 is not represented, no one appears.
My lord, I think the first part is a clerical error.
Okay,
It should be 2, 3, 4, and 5. Because I think he had filed a wakalat nama only for 2, 3. He had prayed for only 2, 3, 4, and 5.
They have not filed any affidavit till now.
No,
they have also not yet filed.
no, my lords. Respondent number 1 is represented by my lord.
One has filed saying that no intentional, and he was no knowledge about the issuance of the notice. One
1, yes.
affidavit.
Yes, 1 has said like that. That we understand because that is not intentional. But my lords, with respondent number 6, he has admittedly mentioned that he has no intention.
Submitted by the respondent number 6. We promise to. He has no idea. Probably he need to engage advocate. This respondent number 6.
His letter looks like it has been drafted by an advocate. And I'm sorry to say this, but it appears to be, I mean, the terms used a little bit here and there.
Now with the use of AI, you do not know how. If one file will also not find the response. One is represented. And today, on the cause.
Let us see the other respondent, let them file, and
Yes,
we'll
certainly,
see
my lords.
on the
Yes,
next date.
Yes.
We'll decide what
Yes,
to do.
certainly, my lords. I mean, I feel it's my duty, my lord, to bring it to your
Yes,
honorable.
that's correct. And it was filed earlier. You have received the copy.
Yes, my lord.
Okay. Who represent the other? Okay.
Also, I'm representing the respondent number
When
one.
are you filing?
On 23rd July 2026.
Have you filed?
Yes, I've
For
already
respondent
filed
number?
the
For respondent number?
one, Lordship.
One only. And what about this 2, 3, 4, 5?
It may be represented by other.
Okay, he is not present.
He's not present today.
Okay. On his prayer, he was granted for the 2 weeks. So what is to be done then? They have not yet filed. Let them file. And then on the next date, we'll see what to do with this respondent number 6.
Certainly, my lord.
And probably this respondent number 6 has also, although this has written, but then he has not continued with the construction.
I'm not sure about this.
What he says in this paragraph,
Yes, yes.
until then he is also not doing. So that is there. But then he has no idea the effect of
Because, my lords, in the PIL,
the notice.
because that stretch of road, my lords, I'll just give your lordship the background, has two aspects. There are two aspects. One is, my lord, one is the prohibition order, my lords. There is an order of this court saying that you cannot do any constructions, my lord. And the other, my lord, is half of that road is within a restricted area. So there's an order of the government that says that this area has to be preserved, the beauty of this area has to be preserved, and no construction should be done at all. So he has constructed it in the protected area, my lord, in the area, in the restricted area. And that is the reason why he was writing all of these things, my lord.
Even the respondent number 1 also says that not all the land possessed comes under that restricted.
Yes.
Says.
Yes.
So it appears that proper examination,
Yes.
verification is required. Okay. Mr. Joseph Lad Chandima. Ranthale, Mike has queued appearing for the petitioner. Mr.
Johnny L. Tocho.
Counsel. For the respondent number 1. He is also present. And submits that he has already filed the affidavit in respect of the respondent number 1. Staff. Mr. Jordan Puya Namte, who earlier appear on behalf of the respondent number 2, 3, 4, and 5 is not present in the court today. No one represented. No. Okay. His associate is also not present today to apprise the court. Why? Okay. The respondent number 6 also is not represented, although he has filed. He has submitted a written statement of defense on 13/7/2026 directly to the court without engaging a counsel. Stop. Since the counsel appearing on behalf of the respondent number 2, 3, 4, and 5 remain absent, comma, the counsel is granted further 2 weeks' time to file the so-called reply of the respondent. Wakalat nama is not. Okay. Not yet filed. Wakalat nama also not yet filed, although he appeared. 2 weeks' time to file Wakalat nama as well as the affidavit, as well as so-called reply on behalf of the respondent 2, 3, 4, and 5. Stop. Accordingly, list the matter again on. When do we fix it? After 2 weeks would be. After 2 weeks would be on 19.
Certainly.
Okay. Okay. We'll fix it on 26. Let us see.
26 is a holiday, my lords.
Well, sorry. Not 26.
Well, 27
Not
is
26. Sorry,
possible.
sorry. 19 only then, in that case.
Or 25th also is possible.
Hmm?
The 20, we can do it on 24th also.
No.
Or
We'll fix it on Wednesday only. 2nd September then.
Certainly.
Okay, 2nd September, huh? On which date this court shall consider passing order, appropriate order on with respect to appropriate order in respect of the respondent number, just a minute, huh? Written statement filed by the respondent number 6. Okay.
Certainly, man.
Item 6.
Lordship,
Yes.
as per Order 12/6/2026, we have asked permission to amend the prayer portion of this PIL. So we have filed our IA on 21/7/2026, seeking application to amend the prayer
Okay.
portion of the PIL.
And probably you are already allowed to file. Granted liberty to file. I mean, allow such. Yes, it's 1/7. It was already allowed, I think. Okay, anyway. You can allow. Yes. You can allow to file or amended petition to the prayer portion?
Your Lordship, I have no objection. However, this PIL is not maintainable.
No, no.
I would
So
like to raise,
let her amend the prayer.
Even if
Let us
the
see.
prayer portion is amended, Your Lordship,
Let us see what she amends.
even if the prayer portion is amended, Your Lordship, the PIL is not maintainable because this PIL, this entire subject matter of the PIL relates to solid waste or liquid
Amendment
waste.
already allowed.
Yes.
1-7. Already allowed to file this application. We'll allow this and let them file. We'll see. If thereafter also, if it is not maintainable, we'll dismiss. Consider dismissing the PIL. Okay.
Yes, Your Lordship.
Hardness.
Rosalind L. Park.
Land counsel for the applicant. This is an this by filing this interlocutory application, the applicant is seeking leave of this court for amendment of the prayer portion of the PIL petition in terms of the liberty granted by this court on by order dated 1/7/2026. Start. Accordingly, just a minute. Sir. The Land Council appearing on behalf the government advocate appearing on behalf of the state respondent has no objection. Accordingly, the prayer is allowed. The petitioner is allowed to amend. And upon consideration, the prayer for amendment of the prayer portion of the petition is allowed for effective adjudication of the issue involved in the petition. So, the amendment petition shall be filed within 3 weeks. 2 weeks.
Yes, Lordship. 2 weeks, Lordship.
Okay. With the above, this IA stands allowed and disposed of. Okay.
Obliged, Lordship.
In the main, are Miss so and so and respondent so and so. Are you appearing here?
Yes, I'm representing on behalf of respondent number
Okay.
7.
Okay. Then Mr.
Johnny L.
Land Council. I also had Miss her name first, and then Mr.
Johnny L.
for respondent number
7.
7 and Mr. 6. Okay, respondent number 6. Mr. Okay. 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 Name not yet not reflected. Okay. Okay. In view of the order first today in IA and so on, the petitioner is granted liberty to amend the prayer portion of the writ petition. Stop, List the matter. After when?
Any date, Your Lordship. However, the maintainability of this PIL may be kept open.
Okay. There will be after allowing this amendment,
Yes, Your
that
Lordship.
will be taken up. Okay. 2nd September. Okay. 2nd September. Stop. The registry shall reflect the name of Mr. is counsel for the respondent number 6 in the cause list. Okay.
Obliged, Lordship.
Orders, item 7.
May it please your lordships, I'm appearing on behalf of the state respondents number 1 to 8 and 12 to 15. Your lordship, as per the last court order dated 29/7/2026 in the second para, your lordship, I was directed to submit the verification report. Your lordship, the same has been prepared by the director of the UDNPA department, and it has been forwarded to the undersecretary UNDA department seeking instructions as to whether the beneficiaries who no longer use the the space for parking as per the terms of agreements of PAHO scheme may be given an opportunity to be heard, your lordship. So if I may be granted at least another 3 weeks time to file the necessary affidavits, your lordship, and also place the agreement on record.
Okay, there was the direction.
Second para of the 29/7/2026 order, your lordship.
Twenty-nine?
29/7/2026, para number 2, your lordship.
Okay. So you need, how much time you said?
Your lordship, in the same order, I have been given 3 weeks time to produce other documents as well. So if I may be also granted another 3 weeks time to file the verification report.
Okay. Mr. Joseph, huh? Land counsel for the petitioner. Stop, huh? Miss,
Lalnu Lu, your lordship.
land counsel appearing on behalf of the state respondent number
1 to 8 and then 12 to 15, your lordship.
1 to 8 and 12 to 15. Praise for how much time? 3 weeks.
Yes, your lordship.
3 weeks time to comply with the direction of this court on 29/7.
Yes, your lordship.
2026. The direction contained in the order dated 29/7/2026 within 3 weeks. Huh?
Yes, your lordship.
Okay.
My Lord, with regard to para 5 of the particular date, C of the traffic and the ANC for the respondent number 9. The ANC were related to constitute joint verification traffic congestion. Lordship, accordingly, as said by the ANC, a team was constituted on 31st August, 31st July, and physical verification was conducted day before yesterday, on Monday. And yesterday itself, there was a meeting reviewing the verification report, and it is about to finalize as of now, Lordship. And the affidavit may be filed to that effect, maybe a week's time or yes, maybe 2 weeks.
Okay. Mr.
Tilan Siyama.
Okay, land counsel appearing on behalf of respondent number 9. Also submits that in compliance of the direction dated 29/7/2026 at para 5. Verification was conducted.
Joint verification
Joint verification was conducted on
4th, yesterday.
4th.
Okay.
Lordship, Monday,
4th.
3rd.
3/8/2020. Report has been submitted?
Report not yet submitted.
Not yet, okay.
Not yet submitted.
Conducted.
Report.
However, the report is still awaited. And then, therefore, he prays that he may be allowed 3
Week's
weeks.
time, Lordship.
Okay, 2 weeks time to bring on record the report by way of filing additional affidavit. Stop the prayer made by the counsel for the respondent is allowed. Stop accordingly. The list accordingly allowed, huh? Stop, huh? List a matter again on second, huh? 2nd September.
Yes.
Okay.
My Lord, instead of the petitioner, this is the learned amicus.
Sorry, amicus, huh?
Obligement.
And Lordship, my name may also be reflected in cause list,
Hmm?
like the previous.
Name,
case.
okay.
Yes.
His name, huh? Similar होता reflected in the course list. Registry is directed to reflect the name of Mr. Swenson for Land Council for respondent number 9 in the course list. Okay.
What's up, like?
Item 8.
Your Lordship, this case is a IA condemnations of delay of 553 days, and we have already filed objections. Since my senior, the leading counsel who taken up this case, Victor Erate, is indisposed. So if the matter may be taken,
They have filed objection. You have filed objection.
Yes,
Need
Your
hearing
Lordship.
then.
Yes. The leading counsel, he have called me, and since he have personal health problem.
Okay. Miss
H. Vanalzami,
Land Council submitted the leading counsel for the respondent. What is his name?
Victor Enrate.
Okay. Leading counsel for the respondent number? Sole respondent?
yes, Your Lordship,
Okay.
all the
Agent
respondents.
disposed, therefore she press for adjournment of the matter, to which Miss Mary L. Kante, Land Council for the applicant has no objection. Accordingly, the prayer is allowed. List the matter after
Next week, Your Lordship.
next week, after a week. Okay, on a
12th,
date to be
if
fixed by
possible.
the registry.
Your Lordship, if possible, 12 August.
12. Okay. Matter again, as requested, come on, list the matter again on 12 August. Okay.
Much obliged.
Item 9.
Lordship, I have filed the affidavit in respect of the notice upon the sole respondent. And I have filed that affidavit on uh, on 24/7/2026, Your Lordship.
This is with regards to respondent number?
Sole respondent.
Oh, sole respondent.
Yes, and the
Are you
respondent.
appearing on behalf of the
My
respondent?
lords, today I don't have any wakalatnama on record,
Okay, but appearing
but my lords, yes.
on instruction.
Yes, on-
Okay.
Just that, my lords, we haven't received the whole memo of appeal. That may be supplied. my lords.
Okay, you furnish,
Yes, yes, I have extra copy
Okay.
with me. I'll furnish you.
Mr.
Johnny L. Tocho.
Land Council for the applicant. Johnny L. Chuang, huh? Land Council for applicant. Mr. Jordan, huh? Land Council put appear on behalf of the sole respondent and request and then praise for some time to file his power. Okay. He further submits that the copy of the memo of appeal has not been furnished to the respondent. Mr. Johnny Land Council for the petition shall furnish a copy of the memo of appeal to Mr. Jordan appearing on Land Council appearing on behalf of the respondent during the course of the days. Stop, huh? As requested, list the matter after 2 weeks. Okay.
Right.
Item 10.
Notice upon the respondent number 2, the
But in this case, TCR has been received, so let paper book be prepared and a date may be fixed for hearing.
Okay. Heard, Mr.
M. Biswas.
M. Biswas, Learned Counsel for the appellant staff. Also heard Miss Mariel Kangte, Learned additional PP for the state staff. It is seen that the paper book has been received. Staff, accordingly, the registry shall prepare a paper book and furnish a copy each to the parties. Here also, this is also box.
No, this is NDNPS.
Okay. No private respondent. You will represent respondent number 2 as well.
Yes, Your Lordship.
Okay. For the respondent, Mary L. Kante would be for respondent number 1 and 2. Huh? Okay. Accordingly, the registry shall prepare a paper book and list the matter after preparation of the paper book.
My Lord, I
Your Lordship.
pray for a fixed date, my Lord, since I am coming from outstation, so
So now we do not know how long it will take.
23rd of September.
Okay. I think within 4 weeks they will be able to prepare. Okay. Then after 4 weeks will be September
23rd.
23rd of September. Okay.
Your
As
Lordship,
requested, comma,
Yes, sorry.
list matter on 23rd September.
Your Lordship, paper book to be prepared at the expense of the appellant, because this is not a jail appeal.
Yes. Then registry is directed to prepare a paper book at the expense of the appellant and furnish a copy to the counsel appearing on behalf of the parties. Okay.
I'm with you.
For hearing, item 13.
Your Lordship, may I make a mention for one unlisted item? We have filed one case this morning, criminal petition, to be listed for tomorrow, my Lord, because the matter is pertaining to challenging of the order of the Special Court, Prevention of Corruption Act. Tomorrow. And another matter is also, may I make a mention for my friend? This is similar matter, my Lord. These two items will be taken up tomorrow.
Okay.
Yes. Much obliged.
May I plead your Lordship?
Yes.
Lordship, I beg to mention item number 2 and 3.
Okay.
Lordship, my senior SK Mehdi, he is on legs and he wishes to appear physically. Lordship, can it be fixed on 14/8?
Phone number 4, 5, and 6. Okay. When you say? When?
14/8/2020.
14/8.
Your Lordship, I'm for the petitioner in item number 3.
3.
Yes, Your Lordship.
So there is a request for listing this matter on 14th by the petitioner in item 2.
Item 2 and 3.
2 and 3.
So, my Lord, I'm for the petitioner item 3. And in that case, the CGC from ISOL has to file, has asked for time for filing affidavit. So if the matter may take after 3 weeks, Your Lordship. In the meantime, Your Lordship, the petitioner also pray for filing additional affidavit, Your Lordship. If they are praying,
Petitioner also.
yes, Your Lordship. So if they are praying for time, then let's 2 weeks be given, Your Lordship.
Petitioner wants to file additional affidavit.
Additional affidavit
Okay.
in 3, and the respondents number 4, 5, and 6 also have to file affidavit.
Where to obtain instruction and file affidavit.
Yes.
Okay. So, your prayer has been done. Yes. You're for?
4, 5, and 6 in 3.
4, 5, and 6.
Yes, Your Lordship.
Okay. Okay. Miss
Lordship, I am M. Das, appearing on behalf of SK Mehdi.
Mr. M. Das, Land Council, appearing on behalf of Mr. S.K. Mehdi, Land Council for the petitioner. And Mr.
Jonathan L. Sila.
Yes, Jonathan, Land Council, appear for the petitioner in item 3. Huh? C is in. Okay. Okay, Miss, you are for petitioner.
No, respondent.
Okay, it's for respondent. Okay.
Respondent
Yes.
number 7, Your Lordship.
Okay. For respondent number 7.
7 units.
7. Okay, you want, okay. Then Jonathan first, huh? Mr. Jonathan, Land Council for the petitioner. Prays for 3 weeks time to file additional affidavit. Earlier you made a prayer, this prayer?
For the first time.
First time?
Yes, Your Lordship. Because
Okay.
we'll get it.
What additional affidavit?
My Lord, it's, if so advised by the petitioners, Your Lordship.
If so advised.
Yes, Your Lordship. There are some certain facts which have to be given to the court, Your Lordship.
Then respondent, they want to file additional affidavit.
4, 5, and 6 have yet to receive instruction to filing affidavit.
4, 5, and 6.
Yes, respondents.
You are for respondent also?
No, that's what
Your
his
Lordship,
senior-
I appear on behalf of respondent 456.
Are you seeking time?
Yes, Your Lordship.
Okay. Then can it be allowed to file additional affidavit in the petition?
So we are praying.
What new development has taken place?
Because, Your Lordship, there are certain, with regard to item number 2 and 3, there are some common petitioners. So something has to be done with that, regarding that. My Lord, the item number 3 and 2 are clubbed together.
Yes.
And some of the petitioners.
You are in item number 3.
3. Item number 3 we have filed earlier than item number 2. Then item number 2 was filed later. And there were some common petitioners there. So certain deletion of names have to be there. So that we have been before the court.
Okay.
And so we'll need to file an affidavit on that regard, Your Lordship.
Okay, Mr. Jonathan, and counsel for the petitioner submits that in view of the clubbing of these two writ petition, certain new facts have been
Yes, sir.
found. New facts has cropped up in the writ petition number 148, 2023, and in view of therefore he submits that he may be allowed to file additional affidavit for addition and deletion of some names.
Right.
So that will be amendment.
Not amendment, Your Lordship. It's the issue is this, Your Lordship. Some of the petitioners who have already filed WPC 136, Your Lordship, that's item number 3.
Okay. Okay.
And without the
Additional affidavit, if so advised, huh?
yes,
Staff.
if so advice.
Okay. Miss, her name, you have written, no? Now, counsel appearing on behalf of the respondent number 7, and Mr.
Lian Meng Tanga on behalf of my senior
Now,
CGC.
counsel appearing on behalf of
CGC for
Okay,
respondent
yes, Jaran Sampuri, Dana
4,
CGC,
5, 6.
for respondent number 4, 5, and 6. Also pray for the 3 weeks time for filing affidavit in opposition. Stop. Who else? Miss Mary.
Your
who
Lordship,
else?
I represent the state, that is respondent number 1 to 3.
1 to 3 is also filing an affidavit.
We already filed.
Already filed. Okay. Miss. Okay. In view of the above, and as prayed for by the Lana Council for the parties, at least this matter after 3 weeks. Stop. Miss Mary L. Kangte, Lana Government Advocate, is also present on behalf of the state respondent. Okay. Okay.
Obliged.
Much obliged.
For admission, item 1.
Your Lordship, on behalf of respondent number 16, I have filed my show cause reply affidavit yesterday. I don't think it's on record yet because we have to sort out the pagination. There's a new notification with regards to how the pagination has to be made in the affidavit. So we have to sort out today, Your Lordship. So if this matter can be adjourned for at least 2 weeks, Your Lordship.
2 weeks. Otherwise, you have filed
I have filed.
affidavit. Okay.
And I have served a copy to the other parties.
Okay. Miss.
Your Lordship, I'm appearing on behalf of my senior, Miss Valentina
Okay.
Ladinpui.
Okay. Your good name?
Zodinpui Tsagtuak. The learned
Your name is also there?
No, Your Lordship.
Okay.
Mine.
Land Council appear on behalf of Miss Valentina Ladinpui, Land Council for the petitioner, staffer. Miss Mary L. Kangte, Land Council appearing on behalf of respondent number
16, Your Lordship.
16. Submits that she has already filed affidavit in opposition. Affidavit.
Yes.
Okay, on behalf of the respondent number 16. However, pagination.
Yes, the same is not on record yet since I
Okay,
have filed
however,
it
the same
yesterday.
is not on record. Stop. The registry shall verify and place the matter along with the affidavit filed by the respondent number 16. Okay, on the next date, next date, stop, is requested, the next date is fixed or just after 2 weeks?
After 2 weeks.
Okay, is requested, at least a matter after 2 weeks. Okay.
Item 4.
Your Lordship, in this matter, I have the instructions to appear on behalf of respondent number 1 and 2, and I have filed my power on behalf of respondent number 2. If I may be given just a week time for filing show cause reply affidavit.
Okay. Mr.
Philip Vamal Soma, on behalf of my senior Valentina Aldinpui.
Lani Council, appearing on behalf of Miss Valentina Landingpui. Stop. Miss Mary L. Kante, Lani Council, appear on behalf of the respondent number 1 and 2.
Your Lordship, I'm appearing for respondent number 3.
Filing Wakalatnama. Wakalatnama already filed, Miss Mary?
Yes, Your Lordship.
Okay, Wakalatnama. And prays for a week time to file affidavit. Stop, Mr.
Elias Ramsfona for respondent number 3.
Lani Council. You are also appearing for the first time?
No, my lord.
Earlier also appeared?
Yes.
Have you filed any affidavit?
No, my lord, I'm praying for 1 week's time for filing
Okay.
affidavit.
Appearing on behalf of respondent number 3.
Yes, my lord.
Also made similar prayer.
Your Lordship, if I may, the council, Miss Valentina Aldinpui, she's indisposed due to her.
Okay, when do you want then?
2 weeks, my lord.
Okay, 2 weeks. Also made a similar prayer. Stop. Is then councils, then a petitioner submitted, Mr. Swenson submits. Land Council submits that Miss Valentina Laldinpui is indisposed. Therefore, pray for adjournment of the matter for 2 weeks. Then thereafter, Mary, Land Council, Miss Mary L. Kangte, Land Council, would appear on behalf of the respondent number 1 and 2 and prays for some time to file affidavit. Mr. So-and-so also made a similar prayer. So, Stava is prayed for by the Lana Council for the parties, list a matter after 2 weeks. Okay.
Item 5.
Lordship, this is the criminal revision petition, and both of us are ready for disposal, Lordship.
Okay.
However, Lordship, there is one matters, which is item number 6. I think they wants to adjourn the matter. If your Lordship permits, then it's my learned friends are there.
Lordship, if I may, Your Lordship, I'm appearing on behalf of the petitioner in this item number 6.
Item 6?
Item number 6. Since they are taking some time in item number 5, Your Lordship may allow us to adjourn this matter, item number 6.
Okay.
Since the learned counsel for the respondent, that is Mr. C. Zoram Thana, he's indisposed, he's in the hospital right now.
Okay. Mr. C. Joram Chana, non-counsel for the respondent number 2, is stated to be indisposed. And in view, and accordingly, it is prayed that the matter may be listed
after. Lordship, if this may be listed on 18th of August.
Okay. Pray for listing this matter on 18th of August, to which Miss, you are for petitioner?
I'm for the petitioner.
Okay. Your good name, what was good name?
H. Lalmal Swami.
Okay. H. Lalmal Swami. Non-counsel for the petitioner has no objection. According, the prayer is allowed. List matter on 18 August. Okay.
Deeply obliged.
So this is item 5.
Item 5, Lordship, yes.
Criminal revision.
Lordship, yes, criminal revision. And Lordship, this is regarding the NDNPS case. Methamphetamine, Lordship.
What case?
NDNPS.
Okay.
Lordship, both the respondents who were the accused were arrested on 15/12/2023 at around 3 p.m.
This is by Union of India?
Union of India, Lordship. I'm the special PP.
Okay. The accused.
There are 2 accused, And both of them were discharged at the stage of consideration of charge. Without
How many
taking any
accused were
evidence.
there?
There are 2 accused.
2 accused. Both of them have been discharged
Yes, Your Lordship.
at the time of
At the
framing
time-
of charge.
Yes, framing of
Hearing on the
charge.
question of framing of charge.
Yes, yes, yes. Due to the violation of, as per the learned special judge, there was a violation of 52A of the NDNPS Act. And because of that reason, both of them were discharged.
Violation of?
Violation of 52A of the NDNPS Act.
Okay, what is that? (52A).
52A, Lordship.
Okay, possession of essential narcotic drug.
Disposal of seized narcotic drugs and psychotropic substance. Lordship. And Lordship, the
52A.
52A.
This is a possession of essential narcotic drug.
Lordship, yes. And in short, Your Lordship may take Lordship to the impugn.
No,
order.
this 52A is under section 52A was registered against the accused.
Yes, Your Lordship, it says that this.
So let us see the FIR then.
Lordship.
Where do we find?
It's in the charge sheet copy, Your Lordship. Record of intelligence input.
Just a minute. Charge sheet copy. Where is the charge sheet copy? Page?
Page 16, 16. Record of intelligence input. Lordship, it's not in the revision petition, it's in the different bunch, Lordship.
16 is your petition only.
Not in my petition, Your Lordship. It's in the separate one, final complaint sheet.
16
16.
of your petition.
Not in my petition, in the final complaint sheet. It's in the, seems that it's in the different bundles.
Okay. This separate bunch also filed by you.
Yes, Lordship, file.
Whether record was called for here in this case?
Yes, it was called, Lordship, if I'm not mistaken.
Is this a record? Department of Revenue. No, which court has disposed of? Must be special judge NDPS.
NDNPS, Lordship, yes.
Or what Department of Revenue? What is this? Just a minute, huh? Hmm? Yes, please. Listen. Just a minute, huh?
Page number 16.
Okay, just a minute, huh? Whether record. This bunch was filed by you, or this is from the record?
It seems that this is from the record, Your Lordship.
This is from the record?
Record, Lordship.
Okay, I thought it was filed by you. Okay, page?
Page 1616.
16.
Record of intelligence input.
Okay,
This
what
is
is
the
that?
FIR, Lordship. May I read, Lordship?
Yes.
Today, that is 14/12/2023, at about 18 hours, officers of DRI Aizawl Regional Unit received a specific intelligence input to the effect that a substantial quantity of methamphetamine tablets concealed in a Ford EcoSport bearing registration number such and such is on the way to Aizawl from Churachandpur, Manipur via Ngaupa, and the said vehicle would approach Aizawl, Mizoram in the late night of 14/12/2023. And based on this intelligence input, and the officers of the intelligence form a team, and they proceeded to the outskirt of the Aizawl. And on 15/12/2023 at around 3 p.m. On 15/12/2023 at around 3 p.m., both the respondents were arrested.
Where do we find that?
Lordship.
They intercepted.
Yes, it's in the Lordship, second page of that book, second page, paragraph number 2.
Page 17.
Page 2, Lordship, page 2.
Oh, page 2.
Lordship, yes. And page 1 is regarding the FIR, that information. And Lordship, I may be allowed to start from paragraph number 1, which is at page 1.
Page 2.
Lordship, page 1, paragraph number 1 is
What is
regarding the
this page?
information.
Page 1 is?
Page 1, paragraph 1, Lordship, may I read?
Just a minute, sir. What is this document? Page 1.
Page 1, Lordship. A brief history of the case, which is at column number 5.
This is charge sheet?
This is charge sheet. This is a final complaint sheet submitted by the Union of India, Lordship.
Okay. Yes.
On 14/12/2023, the officers of the Directorate of Revenue Intelligence, DIR, Aizawl Regional Unit, received a specific intelligence input to the effect that huge quantity of methamphetamine tablets transported in a concealed manner in one SUV EcoSport bearing registration number such and such, and the said vehicle is on the way to Aizawl from Churachandpur, Manipur via Ngaupa, that the vehicle was stipulated to reach Aizawl in the early morning of 15/12/2023. Acting on the input, the officers, along with two independent witnesses, started from DRI office Aizawl at about 8 p.m. on 14/12/2023 and headed towards Seling. Seling is around 40 kilometers from Aizawl, Lordship. 40 kilometers from Aizawl. And at paragraph number 2, on reaching Sakei Bangla, which is between Seling and Tuirini Bridge, at about 10 p.m. on the same night, the officers, along with the independent witnesses, started mounting surveillance of the said vehicle. At about 2 a.m. on 15/12/2023, the teams then moved further towards Tuirini Bridge to look out for the incoming vehicles. Then at about 2:30 a.m. on 15/12/2023, the reported vehicle was spotted on the roadside before reaching Tuirini Bridge. On approaching the said vehicle, the officers found two male occupants who introduced themselves as number 1, Sri Paulianthang and Sri Jangkolen Kipgen. Both of them were the accused, Lordship. Presently residing at S. Toljang village, Tuibong sub-district, Churachandpur district, Manipur. Upon inquiry, both Sri Paulianthang and Sri Jangkolen Kipgen denied carrying any contraband goods. The officers then carried out personal search of the two persons at the spot after availing them an option to be searched, but nothing was recovered from their immediate possession, then the officers issued spot summons to both of them. Since it was still dark and the place being on the highway in the middle of the thick jungle, and upon their request, the officers, along with the independent witnesses, brought both persons and their vehicle to the DRI office Aizawl. And we have annexed the spot summons and the others relevant documents. On reaching DRI office at Aizawl at about 5 a.m. on 15/12/2023, the officers once again inquired to both the persons whether any contraband is being concealed in their vehicle. However, they denied the same. Then, at about 6 a.m., the officers started rummaging the intercepted vehicle thoroughly in the presence of the two independent witnesses and the two occupants, drivers of the vehicle. After the extensive and thorough search, the officers discovered a secret compartment constructed under the toolbox space at the back of the car. The secret compartment was taken apart from the exterior and accessed from the rear bumper. Concealed inside the compartment, the officers recovered 7 brick-sized packets containing suspected methamphetamine tablets. Each of the tablets bore 2 golden holographic labels. The bigger label was inscribed with a foreign script above the mark 3030 export only, and the smaller with number 1 quality. The packets were taken to the office premises and weights measured. The packets weighed 100 gram, 1000 grams each. Upon proper verification, each brick size packets contained 50 small blue colored plastic pouch, and each small plastic pouch contained 200 tiny brick colored tablets mingled with few green colors. The tablets bore mixed marking of WY and R on them. Thereafter, the officers conducted a preliminary test of the tablets by using a field testing kit. The test showed positive result of methamphetamine. The whole process of rummaging the vehicle recovered of the contraband from the vehicle. Verification and preliminary testing of the recovered contraband was carried out in the presence of 2 independent witnesses and the 2 occupants, drivers of the said eco vehicle. Thereafter, weighman sheet was prepared by the officers, and a total of 70,000 tiny brick color and some green colored tablets suspected to be methamphetamine were recovered. The recovered contraband of 70,000 tablets suspected to be methamphetamine value at rupees 7 crore only. It was 7 crore possible. The conveyance along with the documents value at rupees 3 lakhs only, and 2 mobile handsets of the apprehended persons having no commercial values were seized under the provision of the NDNPS Act 1985 by the officer vice seizure case number such and such dated 15/12/2023 with the total seizure value of rupees 7 crore and 3 lakhs. Inventory seizure lists were duly prepared by the officers of, and a copy of each duly received by both the accused. Seizure proceeding was completed at around 10 a.m. on 15/12/2023. The seizure proceeding was completed at around 10 a.m. on 15/12/2023. Thereafter, statement of both the accused were obtained and they were arrested on 15/12/2023 at 3 p.m. under the provisions of the NDNPS Act 1985. The arrested accused, Sri Paulianthang, in his voluntary statement dated 15/12/2023, stated that he was not the proper driver of the seized vehicle, that is Ford SUV EcoSport bearing registration number such and such, and the same belonged to a passing friend of his whose name is Mang Zakam. He further stated that he was asked by Sri Mang Zakam to take vehicle to Silchar for servicing with a promise to reward him. Accordingly, upon his return, he invited his friend, the co-accused Sri Jangkolen Gipken, to accompany him. On being asked, Sri Pao Liantang in his above cited voluntary statement stated that Mang Zagam, was just a passing friend with whom he used to work as mystery labor for the past few years. He know his full name, that is Mang Zagam, but he did not know his surname. He was told that he lived in Kaprang village, but he never asked him his detailed address as he did not have any need for it. He, however, disclosed his contact number as such and such. He did not know whether he had any other number or not. Thus, this article is a narcotic drugs and psychotropic substance of the commercial quantity. Sri Pao Liantang and Sri Jangkolen Kipgen have been found concerned in carrying, transporting, possessing, importing, or in any manner dealing with the narcotic drugs and psychotropic substance of foreign origin. Hence, they were arrested under 42, 43 of the NDNPS Act 1985 for violation of Section 8C and an offense punishable under 21 and 29 of the NDNPS Act. First, information report in respect of the seizure of the instant contraband goods and apprehended persons to the Additional Director General DRI Gauhati Zonal Unit was prepared and sent on 15/12/2023. Report of interception, recovery, and seizure of the goods and subsequent arrest of the accused reported on 15/12/2023 to the immediate superior, that is Senior Intelligence Officer by Seizing Officer Sri Dau Thang Lian Hao Kip, Senior Intelligence Officer, has been made. The suspected persons were taken to civil hospital for medical checkup on 16/12/2023. The arrested accused person and seized article were produced before the Chief Judicial Magistrate on 16/12/2023, along with such and such. Prior to remand, the arrested person under judicial custody, application for certification of correctness of the inventory, taking photograph of the seized article in the presence of Honorable CJM, and for certification of the same, drawing of samples and certifying the correctness of the samples so drawn. The Honorable Court allows the prayer of the seizing officer accordingly inventory of the seized goods under 52(8)(2) of the NDNPS Act 1985, certified samples of the seized article and photographs of the seized article drawn taken before the Honorable Court, duly certified by the Honorable Judicial Magistrate First Class, Aizawl Judicial District. The Honorable Court also passed an order to remand the arrested person under judicial custody for 14 days. The seized article packed in 2 sealed pack was deposited to the Superintendent Disposal Customs Division via GRE number such and such, dated 20/12/2023. Sri Lian Samte, Intelligence Officer DRI Aizawl Regional Unit, was appointed as the investigating officer on 15/12/2023. The sample drawn with a marking from 1A to 7A packed in 1 sealed pack was submitted to the Director of Forensic Science Laboratory Aizawl for chemical examination. File number such and such, dated 16/12/2023. The sample was received by the FSL Aizawl, acknowledged receipt number such and such. Examination report of the sample along with the sample remnants in 1 seal pack was received from Director FSL Aizawl, via letter number such and such. Examination report of the sample showed that the seized goods in the instant case is indeed found to be methamphetamine. The sample remnants and a copy of the sample examination report received from the FSL Aizawl were forwarded to the Superintendent Disposal Customs Division Aizawl via such and such to ascertain the registered owner of the mobile phone number such and such as disclosed by the accused person, Sri Pao Liantang, and to trace other gang member of the illegal drugs syndicate. The SRD-CDR of the mobile was retrieved from the nodal officer Airtel Bharti Hexacom Limited. Further, the registered owner of the mobile phone numbers used by the accused person, that is, used by Sri Pao Liantang and Sri Jangkolen Kipgen, were also retrieved and the call details are given below. So that's such and such. Investigation was conducted on 7/2/2024 to verify the mobile number such and such, which was allegedly used by Mr. Sri Mangzagam but registered in the name of Sri Alex Ne Tinthang. Voluntary statement of Alex Ne Tinthang dated such and such was obtained, wherein he inter alia stated that he neither recognized the impugned mobile number or booked such a number. The mobile number registered in his name is such and such, which was using since around November 2023. Sri Alex Ne Tinthang also stated that he did not know any person by the name Mangzagam. On being asked whether he know the accused persons, Sri Jangkolin Kipgen and Sri Pauliantang, he stated neither of them was known to him. A letter addressed to the officer in charge Rachanpur Police Station, Manipur was issued.
Oh, this is very long.
Very long, Your Lordship. And Lordship, the only reason for discharging both the accused was that, Your Lordship, there are three grounds. Number one is go down receipt was not as per the prescribed form, Your Lordship. Go down receipt. Though we are having a go down receipt, but it was not as per the rules, Your Lordship. Form 1, 2, and 3. That is the first ground. The learned special judge had discharged both the accused. Number one is this go down receipt was not as per the format.
Go down receipt was not
Yes.
as per the format.
Yes, Lordship. Go down receipt was not as per the format.
Okay.
Oh, and Lordship, the second one is that the seizing officer and the officer who prepared the inventory before the magistrate, the seizing officer and the officer who prepared inventory before the judicial magistrate were one and the same person. Were one and the same person. Seizing officer and officer who prepared inventory before the magistrate were one and the same person. And as per the this learned special judge, this is the violation of Section 53 of the NDNPS Act. The learned NDNPS Court says that this is in violation of Section 53 of the NDNPS Act.
'53?
53 of the NDNPS Act.
Okay.
And the third one is, Your Lordship, the samples result received from the FSL were less than 5 grams. Samples received by the FSL were less than 5 grams.
Less than?
Oh, those are the three grounds.
Less than 5 grams.
Less than 5 grams.
So it is normally, it should be 5 grams.
It should not be less than 5 grams as per rules. But at the time of taking the samples before the judicial magistrate, it was more than 5 grams. But when it was received by the FSL, it was slightly less than 5 grams, 4 point something grams. There's a slight 0 point something grams difference.
Okay, otherwise the report also.
Yes, the
After
report.
examination, FSL report has been received.
Yes, yes.
And it came out to be positive.
Yes, it positive, Lordship. It was positive.
Mm.
It was methamphetamine. It was positive.
Okay.
But the learned trial court says that it was slightly less than 5 grams. So this is in violation of the rules. Says.
Well, less than is a violation of?
Less violation of, Lordship, Lordship, this rules, 2022 rules. which is in violation of 11 of the 2022 rules and the NPS Act.
Okay.
So those are the three grounds, Your Lordship. And because of that reason, both the accused were discharged. And Lordship, to argue those three grounds, this go down receipt, I admitted that it was not as per Form 1, 2, and 3 of the rules. We take Lordship to the NDNPS rules, 1989. There was a prescribed format.
Go down receipt.
Go down receipt, Lordship, yes. This NDNPS, Seizure, Storage, Sampling, and Disposal Rules 2022. There were three forms. Lordship, NDNPS Rules 2022. In my book, it's page 170 in my book. There's a prescribed format.
Rules 22.
2022.
I think
In my book, it's page 170.
yours is. Okay. What do we? Okay. Okay.
Lordship, got it? There are three forms, there are three formats.
Oh, yes. Yeah.
Form 1, Form
Just a
2.
minute. Huh? Rule 4, 1.
Lordship, yes, there are three forms, Form 1, Form 2, and Form 3.
Yeah,
As per the
your
learned
page
in my book, page 170.
170.
170 in my book. Mine is 2025 edition.
What rule you said?
This is the Form 1,
No.
Form 2.
It's
This is
Rule 22.
2022, NDNPS, Seizure, Storage, Sampling, and Disposal Rules 2022.
Seizure, okay. And then this is Form
Form 1, Form 2, Form 3. Format is there.
Okay. And then we are concerned with?
We are concerned with the learned trial court had stated that that receipt is not as per these rules. It's not, this rules is not followed.
No, which rule has not been followed? Rules, rule number?
Lordship, it's 5, Chapter 5, Lordship. In the NDNPS, Seizure, Storage, Sampling, Disposal Rules. Chapter 5, Miscellaneous, Repeal and Savings. Next to Repeal and Savings, there was a Form 1, Form 2, and Form 3.
So Form 1, 2, and 3 violated.
Violated, Lordship.
So Form 1 is forwarding memorandum to
Yes,
go down by the seizing officer. This has not been followed.
Yes, and Form 2 is acknowledgement by officer in charge of the go down, and Form 2 is register of material received in go down. So we are not having, we didn't prepare this Form 1, 2, and 3. But we are having the go down receipt, which has been annexed, which has been clearly reflected at page 25 of the charge sheet, Your Lordship. Page 25 of the charge sheet. Page 25, 25, Your Lordship.
Is
25, which is
this is inventory of goods
yes,
seized.
this is inventory.
24.
And, yes,
24.
Yes, Lordship. And 25 at the bottom, it was written that VRE number says in such date dated 20/12/2023 received 2 packages in seal pack said to contain the above goods of seal number also.
Okay, this is only they have just stamped it.
Yes, this is what we are having. This much we can produce before the learned
So this
trial
form, this form 1, 2, and 3
Yes.
are not available. For
not
the police.
available. That is one of the grounds of discharging both the accused. So admittedly, we are not following this Form 1, 2, and 3. So it is admitted fact. This is what we are having, Your Lordship.
This inventory of goods was prepared by
Prepared by the seizing officer, Your Lordship.
Was it prepared in presence of the magistrate or
Yes,
just
yes, it was prepared before the magistrate.
whether the magistrate has signed?
Magistrate 20. Lordship, at page 56. Page 56. This is application for the inventory, and at the bottom it was signed by the Judicial Magistrate, First Class, Aizawl Judicial District, and photographs and warrant of immediate custody is also signed by the magistrate, and list of some.
Whether the magistrate has certified
Yes, Lordship, yes.
that it is in the correctness and truthfulness
yes.
of the inventory.
Inventory, Lordship. Page 63, 64. Oh, it's not. And 65 is the.
Madam Counsel, it appears that we have to hear the entire matters.
Lordship, yes.
Don't you think that we need to prepare, here in this case, we need to prepare a paper book?
Lordship, since evidence is not taken, and
Okay.
so.
Because these documents,
Lordship, yes.
because this will be a kind of a disposal of entire matter, of course, except for the evidence.
Mhm.
We need to appreciate.
We need to appreciate, Lordship, yes.
Appreciate everything.
Appreciate everything, because the
So
learned
because-
trial court, yes.
Learned trial court, we have to show this, and these probably, after showing that these probably need to be examined.
Examine, Lordship, yes.
It appears. Because it appears that everything is there almost.
Everything is there.
Everything
That
is there,
the reason.
only that the format.
Yes, yes.
So this actually, can it be accepted or not?
Lordship,
So
yes.
that will be after adducing evidence only.
Lordship, yes, that is our reason. So because Yeah, because of that format only, it cannot be discharged.
Yes, yes.
Because we have
It appears, it
prima
appears.
facie case. Yes, Lordship. So that
Because
the-
the prima facie, there is a prima facie case against them.
Lordship.
And this is enough for framing charge against the
Lordship,
accused
yes,
persons.
yes.
And then all these things can be brought on the court after adducing evidence in the
Very true.
cross-examination.
Very true, Lordship.
It appears. So, but then to write that, we need to appreciate everything because he has disposed of, discharged in such a case.
Yes.
He will take some more time again.
Some more.
Yours again, I think, will take another hour. And this will be a judgment only, complete judgment only.
Yeah.
I am carrying at least tomorrow one delivery. I am carrying one.
Oh.
So from here it's difficult to carry.
Mhm.
I have only hardly 2 days, 1.5 days. It will be difficult. We need a long, I think, a extensive hearing.
Agreeable.
Hmm.
And my lord, one thing is that
This would be a complete hearing. We need a
yes, my lord.
proper hearing.
Proper hearing is required.
Hmm.
So, my lord, may I just?
I thought this is admission. I didn't see the record.
Hmm.
Admission because if after the admission, so this will be listed for hearing only. Actually, we need to admit this. Need to be listed for hearing. What do you say?
If my lord would take this at the stage of admission, my lord, it can be disposed if it's agreeable on the part of the council, my lord.
No, that is why I'm saying that it will take a long time.
Correct.
Hmm.
Perhaps another day,
Because
my
this
lord.
is entire hearing,
Yes.
and that is also without this evidence, and that takes more. Evidence is no problem. Appreciate the evidence. The evidence is already there. Deposition of the witnesses. But then here without deposition, and then we need to appreciate all these. And assumption, presumption also comes. It appears, and then prima facie, of course, it can be shortened also. But then long hearing, it needed. It can be shortened, saying that there is a prima facie. Otherwise, but then since he has been discharged. He need more, I think, time to place his case.
Also, and we can simplify in this way also. If my learned friend is not objected, then my prayer is that let the case be remanded back to the learned trial court
Can we?
to have.
What do you say?
My lord,
Take the evidence because evidence is required.
Evidence is required. It appears.
Correct.
There is a
correct,
prima
my lord.
facie
But,
case.
my lord, in this case, the basic challenge is to the impugned order is regarding the discharge. So, my lord, to find the illegality in that regard, my lord, is the role of the petitioner at this stage. So, the learned trial judge had taken the materials, had perused the materials available on the records, and that does not exceed the provisions under 227 of the CRPC, my lord. The trial judge had acted in conformity with within the virus.
That
of
is
the
there.
provision.
That he has, of course,
My lord.
after because it depends
And
on
it
the
is
trial.
permissible
It
that-
depends on the trial judge also.
Correct.
And he has probably exercised his discretion. Yeah.
Correct.
And but then it shows that it appears there is a prima facie case against
That has to
the
be
accused,
determined
and
by
then
the
from the face of it, it appears there is a prima facie case against, and this need to be, you see, proved by adducing evidence only. The allegation against, because the recovery you are not denying, you cannot also
correct.
recovery only because there is a deficiency. While at the time of collecting, it was a little more than 5 grams or 5 grams, but then when it reaches there, it came out to be less than, and this will be, you see, this need an argument
Lordship, yes.
how it became and what was who were they present at the time of collecting and was it correct.
Very true, Lordship. Very true.
So these, unless adduce evidence, it cannot just reject outrightly, only because a little less point something found out to be, came out to be lesser.
Lordship, here,
Cannot.
here it says 4.8 grams. So only 0.2 grams.
See,
less.
0.2 gram.
But my lord,
Say the intention, and then as per the rule, it was a
Not less than 5 grams.
not less than 5 gram. But intention was that to collect 5 gram at least. But then where did it go? Need to
that,
do
that issue is not very, my lord, that would not very much affect the proceedings of the case. But my lord, there is one violation of one provision as well. The NDNPS is a stringent provision, my lord. So a strict compliance is required. So Rule 5 requires the seized article to be deposited within 48 hours. And subject to that, my lord, if in case there is a failure on the part of the agency, then an additional 24 hours is granted and nothing beyond that. So they have failed to deposit the articles in the go down within 4 days, my lord.
And
Within
then
a period of 4 days, my
go
lord.
down receipt also. We have seen that in this state, the go down receipt is in a different, maybe not exactly in the format, but then in other case also, go down receipt was in the different format. They have formulated
Yes,
only
yes,
one,
yes.
not these 3, 1, 2, 3, but then one receipt, and that
But the time frame,
but it
Rule
was not
5.
within the time frame.
the time frame
Okay.
has been violated. So that would eventually vitiate the trial. So the learned trial court had taken the stand.
This you then in order to prove, he need to satisfy by showing
Lordship, yes, yes.
satisfy by showing the Supreme
By
Court,
producing some witness.
So
My lord, what has to be considered, what can be resorted to at the stage of discharge under 227 is the materials, the records of the case only.
Yes.
Basically at the charge sheet.
that
at
is
this
what,
stage.
what I'm saying.
My lord.
The entire record from the filing of this FIR and from the report, secret report,
That only has been resorted.
all those it appears, and then physical finding them, and then from the same spot, without they did not leave the place, and the police also. But then in the morning when darkness is
Lordship,
over,
yes, yes.
and that came out these things found from the vehicle. So all these they are having this fact in the record, and see discharge would be a little difficult, because prima facie there is only that the procedure part, why it was not, can be proved after adducing evidence only.
So
But then learned counsel for the petitioner has to satisfy all this. You need to come prepared with all those Supreme Court citation also
Lordship.
under the circumstances.
And,
If
and,
it
and
can
that
be.
has to be proved before the trial court. Lordship. And here the Supreme Court in the case of Lordship Bharat Ambale case also, here it clearly says that mere non-compliance of the procedure under 52A or the standing order or rules, that is the go down receipt and all, there under will not be fatal to the trial unless there are discrepancies in the physical evidence rendering prosecution's case doubtful, which may not have been there. Such compliance has been done. So here it also says that physical evidence rendering is required.
Foundational fact is there.
Yes, foundation
So that is
fact.
why there is a problem.
Mere non-compliance of this go down receipt only cannot be fatal to the trial.
And that is why that and the other day, and probably there is also some ruling that comes under the minor discrepancy.
Minor, yes, yes.
Anyway, so today, even if I hear also, I would not. It will be difficult for me to carry because I already said that is yet to be finished.
I understand.
So from here we have to leave by flight. It's very difficult.
We
to carry the
understand a
heavy
lot,
one.
yes.
So what we'll do is next day we'll fix, and as and when this court sits, we'll take up. Otherwise, no, if it remains so.
Okay.
I've understood the case otherwise, but then it requires that your citation also, all those. Samarade,
My lord.
Lordship, yes, no problem.
the content of all this format also, because if it fulfills the present one, if the basic are is present or is has been reduced here or brought down, then the format whether it can be treated as a fulfilled
Yes,
or
yes.
not. Let's see, because this needs a long one. Okay. We'll say hard, Mr. Land Counsel for the petitioner. Also hard, Mr. Okay. Land Counsel for the
Respondent 1 and 2.
respondent. Staff. However, no, not hard, huh? Mr. So-and-so, Land Counsel for the petitioner, and Mr. So-and-so, Land Counsel for the respondents are present. However, due to paucity of time, the matter could not be heard, huh? Staff. Accordingly, the release this matter. You want date or
After 2 weeks,
After 2
Lordship,
weeks, Madam.
that may not be required. So anytime when it come up, we will
okay?
ready.
After 2 weeks. Okay. This is this as per the record, it says that trial court record, but this is the Ministry of Finance. Is this the trial court record? Trial court record as it was called for. Because this is not the trial court record, the file which we have. Kindly see if this is, kindly see this also. Because we need to record that peruse the trial court record also. So this, if this is not a trial court record.
Lordship, that usually that the file cover is we have submitted in the file cover.
It should be in the written in the file cover, like the Gauhati High Court, Aizawl bench. It should be written.
Should be written.
The special court NDPS or district and session judge or NDPS, etc. But this is Department
Ministry of Finance. Yeah.
Review, etc. I don't know.
Item 7 for orders.
Lordship, this IA 41 of 2025 is an application for condoning the delay of 406 days in filing the special leave petition, and void order dated 11/5/2026. Lordship, void order dated 11/5/2026. I was allowed to file additional affidavit.
This is IA 41.
IA 41, Lordship. It's the condonation of the delay. Here,
Okay.
I'm challenging I'm for the Union of India, Lordship, and I'm challenging the acquittal order.
Notice was issued.
Notice was issued, is represented by my learned friend.
Objection filed.
Objections have been filed, my lord.
Filed.
Yes, my lord. It has been filed, my lord, on the 1st of July, 26. For the main petition, my lord, the same has also been filed, my lord, on the 23rd of April.
Delay of How-
406 days, Your Lordship.
406 days.
406 days.
Challenging, to challenge what order passed by the CJM?
Passed by the CJM, Your Lordship.
What order was passed?
This is regarding the gold bar, Your Lordship. Gold bar was recovered from the respondent. The accused
What was the order passed by the
CJM.
CJM?
CJM, Your Lordship, the order is
Acquitted
in the-
discharge?
It was acquitted, Your Lordship, acquitted.
Okay.
And on the ground that there are two grounds, samples were not drawn before the magistrate, and then the prosecution is unable to prove the case beyond reasonable doubt. That is the two grounds. And Your Lordship, by challenging this order, there was a delay of 406 days, and void order dated 11/5/2026, Your Lordship. So we have tried to dispose of this IA number of this 41 of 2025 on 11/5/2026. However, the explanation rendered by the applicant was not satisfied, and this honorable court had given me a chance to file additional affidavit to explain the delay.
Okay, what have you said in your additional affidavit?
Yes, in my additional affidavit, I have
Where that observation has been made that it is not satisfactorily? On which date?
on 11/5/2026. 11/5/2026.
Between the receipt of the judgment and order
Lordship.
by the applicant on so-and-so and the letter dated.
There's a huge gap between 15/2024 to 05/7/2024.
Let us see your additional affidavit.
Lordship, yes. I have filed on 9/6/2026. 9/6/2026.
Which paragraph?
Lordship, starting from paragraph number 4, page 3. May I read, Lordship?
Yes.
That the received legal opinion dated 08/08/2024 submitted by the Departmental Counsel has been immediately forwarded by the Office of the Applicant Appellant to the Assistant Commissioner Law, Office of the Commissioner of Customs Preventive NER Shillong on 09/08/2024 for information and necessary action. And I have annexed the letter. That subsequently the Headquarters Office in Shillong, void order dated 25/9/2025, informed the applicant appellant that the competent authority had approved the grounds of appeal formulated in the legal opinion dated 8/8/2024, which was drafted by the Departmental Counsel against the impugned judgment and order dated 25/1/2024, passed by the learned Chief Judicial Magistrate Champhai in criminal complaint number 22 of 2021, with a direction to prepare condonation of delay and draft appeal of the said matter. That on 8/4/2025, in a letter vide such and such, the applicant appellant requested the Department Counsel to take prompt action to file an appeal before this honorable court. However, in response to the said letter dated 8/4/2025, The Departmental Counsel clearly stated in his reply dated 9/4/2025 that no formal instruction or approval had been received from the competent authority. That thereafter, the Superintendent Law of the Customs Division in Aizawl, White letter dated such and such, informed the Departmental Counsel that the competent authority had approved the grounds of appeal formulated by the Departmental Counsel. The letter further requested the preparation of the continuation of delay, a draft appeal, and a draft miscellaneous appeal for the stay of operation of the judgment and order dated 25/1/2024, passed by the learned Chief Judicial Magistrate, Champhai, Mizoram. That the matter stated in this are true. So this is the
And then where in the earlier, in the main
in the main is
petition, where is the grounds?
41 of 2025 of the nation.
Okay, in which paragraph? Paragraph
Two. Start from 2, page 10.
To A, B, C, D, E, F, G.
Yes, to the G.
H, I, J.
Till J. Till J is the explanation. I have read out before the Honorable Judge and others. It was already heard, and what I have not satisfied to the court is between the two time gap. That's it. And I was allowed
So this
to
has been
file-
explained.
Yes. Others may seem
So
to
what
be
is your submission? Okay, it appears that sufficiently explained.
No, my lord. My lord, in the additional affidavit that was filed, my lord, at page 8. Lordship may kindly turn to page 8.
8.
8, yes. There, the
Annexer.
The annexes, yes. My lord, the council has annexed the order,
Yes.
which granted liberty to file the additional affidavit, my lord. In that aspect, my lord, there are two time frames that has to be explained. 15/3/2024 to 5/7/2024, and 8/8/2024 to 16/4/2025. There are two time frames that has to be explained, my lord. And they, unfortunately, the council had been able to explain only the time frame, the subsequent time frame, from 8/8/2024 to 16/4/2025. And no explanation has been given
15/3/24 to
to
5/7/24.
2024. No explanation has been given. That is an admitted fact on the part of the council as well, my lord. So in that case, my lord, the same is barred by the limitation, and the explanation accorded is not sufficient to condone the delay, my lord. And in similar proceedings, my lord, the same has been dismissed.
Where is the explanation for this period 5/3/2024 to 5/7/24? Plan counsel for the applicant. Your explanation start from this 8/8/24. Yes, still it appears there is no explanation for this period. Have you seen?
Lordship, yes, I have seen. I have this, but that was in the main.
No, in the earlier, in the main, it was pointed out.
It was pointed out. Lordship.
Para 2A. Not explained this period, it appears.
It's not available, Your Lordship. I have sent the letter, but that is what I have received. Then I have inquired. Then
What you have stated this period? Just have you stated something? No.
Lordship, I have not get any instruction between this 15/3/2024 through 5/7/2024.
Yeah, 15/3/24 to 5/7. So there is a
5/7.
gap of
Mm.
around 4 months.
Around 4 months. Here it says that it was in the departmental office.
What to do? What to do?
Lordship, I cannot go beyond this affidavit. It's up to Lordship.
So at this stage,
But
my lord,
Lordship, I may be allowed to submit some citation regarding I don't know whether it is.
No, did you sought for instruction? Because this period probably after of my observation made by this court, you have obtained all these documents, and for this period, have you sought for a instruction?
I have forwarded this honorable court order.
What was their reply?
Their reply is this much, Your Lordship, which I have stated before, Your
No,
Lordship.
this period. Have you clarified this period?
That was not.
Because for the other period, you have, I think, sufficiently shown.
Maybe, Lordship, they may. I think there may be some mistake on the part of the department.
No, it appears that no.
Hmm.
See
Yes, it appears that because
it appears that
Because
you
there are
have
two-
have a sufficient document because this is the department. You have a sufficient document for the other period, and this period probably they missed out.
they miss out because there are two time gap.
Yes,
One
yes.
is 15/3/2024 to 15/7/2024.
If you want, you just issue reminder. If there is nothing, then we'll have to otherwise have to pass necessary order accordingly.
Lordship, yes. Because it may be somehow it's very confusing because there are two different dates.
No,
One
that is why. That is why
15/3/2024.
they could furnish one period gap, but then other period gap probably they have forgotten. Okay. Mr. See, normally when the appeal is filed, the person wanted to file appeal. Normally it is to be disposed of on merit only. The case. Anyway, let us give just one chance, last chance. And then if he fail, the department also will understand. Otherwise, he will be blamed for.
Yes.
I understand, but my lord, may kindly note that ample opportunity was accorded to the council as well in the prior proceedings.
Last one more chance. No? Okay,
Fair
had
enough.
Mr. Johnny L. Tachong. Also had Mr.
Tarokung Apautu.
Lara Kunga Portu. Land Council for the respondent staff. Mr. Johnny, Land Council for the applicant. Submitted, although he has filed additional affidavit for the period, explaining the period.
Lordship, I have explained the delay between 8/8/2024 to 16/4/2025.
Explain for the period between 8/8/2024 and 16/4/2025. However, somehow he missed out explaining with regards to the time between the receipt of the judgment and order by the applicant on 15/3/2024 and the letter dated 5/7/2024. Therefore, he prays for some more time to inadvertently missed out, Okay, therefore he prays for further 2 weeks time to obtain instruction in this regard. Okay. The prayer is allowed. Reach the matter after 2 weeks. Is 2 weeks enough?
Date may be fixed, Lordship.
Date,
So it will
okay.
be proper So I'll get instruction from the department
Are they-
saying that you have to.
of the instruction. Oh, okay. And to file additional affidavit if so advised, huh? Stuff, huh? Is played for come and list the matter on
2nd September.
2nd September. Okay. Then make it 3 weeks, huh? Instead of
3 weeks.
That becomes 3 weeks. Okay. Okay, finish.